we're going to spend a little time talking about the regulatory platforms and the regulators, as this is part of Albany Law School's program, and we do suspect there's quite a few people interested in the regulatory aspects of cryptocurrency and blockchain. So, Robert, we're going to start with you. Could you tell us a little bit about the initial background on both the IRS and the CFTC as it relates to cryptocurrency and blockchain?
Sure. I'll start with the CFTC. So, as I mentioned before, we have this interesting regulatory environment. We've got 4 agencies that define cryptocurrency type products in 4 different ways. So the CFTC defines cryptocurrencies as commodities, subject to CFTC regulations. Now, the CFTC does not typically regulate the spot markets in commodities. Instead, they're more focused on derivative type products. One example, and one of the more common ones that the CFTC has been focused on, are Bitcoin futures products or other cryptocurrency futures type products. And so to that end, the CFTC has brought numerous enforcement actions against exchanges and other entities that are offering products tied to cryptocurrencies, futures, options, other products of that nature, margin trading, things like that. Without having registered with applicable entities and organizations, without having applicable registrations pursuant to CFTC regulations. And so we've actually seen this recently, we've seen this mostly with CFTC enforcement actions against foreign-based entities that are offering products to US customers and that for various reasons don't have the applicable registrations. And so we've seen sort of the international reach of the CFTC as they've come to a couple different high dollar value settlements against cryptocurrency exchange platforms that are offering products that the CFTC deems to be under its jurisdiction as a commodities regulator. With the IRS, as I mentioned, the IRS considers cryptocurrencies to be property. And so that means when you receive cryptocurrency, you've got to record your basis upon receipt of that property. And when you sell it, you have to calculate your gain or loss and report your taxes accordingly. The IRS has been more and more active, and I think we're going to continue to see them more active in enforcing specifically against tax evasion. And to that end, beginning in 2015 and 2017, and then even more recently, the IRS has gone after a couple different exchanges, some of the larger exchanges in the US, seeking records from customers at those exchanges through what are called John Doe summonses, which essentially allow the IRS to gain access to records within certain parameters approved by a court so that they can analyze those records to identify potential tax evasion. And I think we're going to continue to see that type of activity going forward. The IRS has also reportedly issued tens of thousands of notice letters to folks that they believe to be in violation of tax laws related to their cryptocurrency holdings and investments. And so, a notice letter like that is sort of encouraging that taxpayer to come forth and get right with the IRS before they bring an enforcement action against that individual. And the IRS has actually issued some pretty sophisticated guidance in this area, addressing events like hard forks, which is where one blockchain essentially splits into 2. And when that happens, oftentimes a new cryptocurrency is created. And so they've addressed the tax implications of events like that. They've also addressed the tax implications of events like earning cryptocurrencies through web-based applications, and those transactions are generally also taxable. So, the IRS is typically interested in enforcement and making sure people pay their taxes. And, I think last year, most of us probably noticed there was a question on the 1040 form related to whether you have purchased cryptocurrencies that year or own them. I forget the exact language. I think I expect that we'll see that question or some iteration of it on 1040s going forward. And so these are all signs that the IRS is more and more focused on making sure people pay their taxes related to the cryptocurrency industry. And that's actually a sign that the market is maturing, frankly. So I think, overall, this is a very good sign. And it's a sign that the market is continuing to mature, and that the market is resilient, frankly.
Absolutely. Thank you. I actually am going to ask you to continue, Robert, if you don't mind, on the topic of Bank Secrecy Act, BSA, AML, and FinCEN. So can you move on to the next type of regulatory body?
Sure. So as I mentioned, the Financial Crimes Enforcement Network, which is an arm of the U.S. Treasury Department, their job is to enforce the Bank Secrecy Act. Bank Secrecy Act is the anti-money laundering law that we have in the U.S. that protects us against criminals using the financial system to launder money. And in general, FinCEN has defined actually they were the very first regulator to issue guidance related to cryptocurrencies way back in 2013. Where they defined cryptocurrencies as money for purposes of the Bank Secrecy Act. And they defined the different types of entities in that initial set of guidance that and how they would regulate those entities under the BSA and FinCEN regulations. The key definitions from that first set of guidance are really relate to who is and who is not what's called a money services business. And it's an important distinction because if you are deemed to be a money services business or an MSB, then you are treated essentially very similar to a bank in terms of your anti-money laundering obligations, which means that you have to have an anti-money laundering compliance program, appoint a BSA officer to oversee that program, have ongoing training, periodic independent testing, a whole bunch of very hefty compliance obligations that are all targeted toward making sure that criminals don't use the financial system to launder money and engage in other illicit activities. And so FinCEN in its first set of guidance defined what are now called an exchanger, or in that guidance was called an exchanger of virtual currency. And that is someone that essentially facilitates the exchange of cryptocurrencies on behalf of another person. And so very simply these days, we have a pretty robust cryptocurrency exchange market in the US. These are businesses where you can go and exchange your US dollars for cryptocurrency and vice versa. And cryptocurrency exchanges are typically going to be considered, or in almost every case, going to be considered an exchanger and therefore a money services business that has to have an AML program. Back in that first set of guidance, FinCEN also defined what's called an administrator, which is someone that creates and issues their own cryptocurrency. And in general, administrators will also be deemed to be MSBs. And then they also defined two types of persons who would not be considered money services business. The first are users, so just a person who is using virtual currency or cryptocurrency to purchase goods or services, or use it on their own account, would not be considered an MSB. And later in the following year, they issued an administrative ruling finding that a miner of virtual currencies would also not be considered an MSB. And that's important because the mining industry really is sort of, the linchpin that underpins blockchain networks. And so, FinCEN has found that miners would not be considered MSBs. More recently, in 2019, FinCEN issued new guidance that really provides a pretty comprehensive set of guidance covering a host of different activities in the cryptocurrency industry, things like hosted cryptocurrency wallets, peer-to-peer exchangers, cryptocurrency ATMs, anonymizing service providers, cryptocurrency payment processors, developers of distributed applications, providers of privacy coins, ICO issuers, cryptocurrency mining pools. These are just some examples of the different types of businesses that FinCEN addressed in its 2019 guidance. And that guidance goes through each of these categories of business and provides an analysis that, the industry can use to determine whether or not that type of business activity would be considered an MSB or not. And again, that's a critical distinction because if you are an MSB, you have to register with FinCEN, you have to have an AML program, which is a very serious and big undertaking. And if you're not an MSB, you don't have to have those. So it's critical for any business operating in this industry to understand FinCEN guidance, and in particular to understand if their business activity puts them within the definition of a money services business or not.
Okay, thank you. Pratt, we want to talk about just generally, I think we just went through a bunch of agencies federally. And can you tell us a little bit about the federal versus the state overarching regulatory scheme in this particular scheme, I guess I should say, in this particular area?
Sure. Yeah. there are so many regulators. I think audience members' heads are probably spinning at this point. But let me talk about a couple in the banking and consumer protection space. So for those who aren't familiar with banking law, the U.S. banking system is essentially what's called a dual banking system. One has a choice whether they form a bank under state law or federal law. So there's inherently a bit of an arbitrage and different pathway to do that. And as Kayvon mentioned, a lot of the use cases and applications of cryptocurrency are increasingly becoming bank-like. And so there's a fundamental question, depending on what one's doing, whether that's lending or taking custody of tokens, moving them from person to person or person to place, or just safekeeping them, whether that fundamental activity is a banking one. And that then implicates how one actually goes about their business. Are they doing it federally under a federal banking power, or are they doing it under a state power? And it turns out that other than deposit taking a fiat currency, many of these functions, lending and payments, are not actually regulated under a comprehensive federal regime, unlike the broad sweeping AML regulation from a licensing perspective, whether you're a licensed lender or a licensed payment processor. That's all regulated in the US under state law. And so a lot of the use cases of cryptocurrency will actually be swept into a state law regime whereby the state banking regulators or credit regulators of each of the different states have jurisdiction. Separately, a lot of use cases in crypto have direct customer-facing applications. Maybe the lending product is not a business-to-business lending, but it's a consumer lending product. Or the custodial product is safekeeping crypto for users as opposed to businesses. There's also a dual regime, both at the federal level from a consumer protection standpoint with a couple different agencies. One, the Consumer Financial Protection Bureau, that concerns itself with consumer financial products, as well as a generic industry regulator, the Federal Trade Commission, that will go after payments or other technology companies within its jurisdiction, that looks at consumer protection from a federal perspective. But then you have also the state overlay and, of course, state attorneys generals, state banking regulators, and under a patchwork of a variety of IP and trademark laws and other consumer protection regimes, exists a state-by-state consumer protection regime. So yet again, we have this patchwork approach where while there are federal regulators and federal regulations, every state has its own regulatory regime. And that leads to a structural implication in that oftentimes clients will ask, what's the best state to locate in? Where should we headquarter our business to have the least burdensome approach to building out a business? And it's a little bit of an incomplete question in the way it's framed, because these regulations don't just apply to where one headquarters their operations or where their engineers are based or where they decide to house their CEO or operations. Oftentimes with consumer protection regulation or all of these different licensing regimes, the important question is not necessarily where you're based, but where your customers are based and where you extend yourself economically into. So if you're a California company, if you're doing business in all 50 states, then all 50 state laws will be relevant to you, not just California or your home state.
Yeah, great point. One more thing we really should touch upon is the SEC. So with that, Yev, perhaps you could tell us what constitutes a security when it comes to crypto.
Well, if I can certainly tell you what constitutes a security when it comes to crypto, I'd probably be retired. I don't know. No, I mean, it's definitely, regulatory patchwork and a lot of regulatory scaffolding in determining on the SEC side as well as to what constitutes a security or not. But if you look kind of at the classic Howey test and the Reeves test, I think that is really your starting point. But there's no, as it has been said, there's no one dispositive fact which you can rely on in kind of determining whether something is a security or not. I know that Gensler recently came out to say that the kind of the continuum that has been recently been talked about, kind of about the morphing of from a security into a commodity is probably not going to be around for very much longer, but that's really been relied on by a lot of projects and the decentralized community at large. So yeah, I don't have a very clear answer, but I would say in my practice, I've really relied just on what's been public information, following kind of the turnkey jet decision, following what's happening with Ripple, the Ripple case at the moment, and just drawing analogies on what we know as really the safest type of counsel.
Thank you. Yeah.
If I could jump in, because I deal with the SEC on these sort of issues pretty regularly, and there are, yeah, as you said, there's no, that's right, there's no one test. It's very facts and circumstances based. The baseline and where this sort of, I think it's helpful to sort of look at where the SEC got started in this, and then what some of its concerns are to understand what some of the tension is and how they're defining security. So the definition of security in the securities laws, there's an enumerated list, a specific list of things like a note, a bond, things like that we all think of as a security. And none of those is a cryptocurrency token, of course, because these laws were written back in the 30s. But there are some big catch-all categories that are included in the definition. And the one that has been used primarily in this area is an investment contract, which has been interpreted to be any investment contract or scheme. The idea here is if you enter into what is effectively an economic relationship that looks like a securities type transaction or scheme, it's going to be a security. And the courts and the SEC use a test called the Howey test that's now 75 some years old that basically asks a few key questions, like, is this an investment of money in some sort of common enterprise with the expectation of profits based on the work of others, which is, is sort of some core team that's going to go out and do something with your money. You're just going to sit back and passively invest and expect to end up with more because of your investment. And if it looks like that, it's a security, at least according to the SEC. The difficulty that they have is that the Howey test, which originally evolved out of an investment scheme where you could invest in an orange grove, and the person who was selling the investments would essentially manage the orange grove and you would reap part of the profits. And that test has been used for a lot of other things. It's been used to look at whiskey barrel investments and investments in beavers, all sorts of things. The thing that they tend to have in common is that the object that you're investing around is not itself a security. If what you have is actually a certificate that represents ownership in a company and voting rights and looks like an actual security, it's easy. That's on the list. What Howey is used for is all these things where you come up with an investment scheme built around something that isn't obviously a security. And so you have to look at all the facts and circumstances to decide, when you say you're selling participation in an orange grove, are you really selling an investment in some common enterprise where you're putting your money with somebody else so they go do something and generate a return? The problem with that is, of course, when you invest in an orange grove, the investment scheme might be a security. For digital assets, the initial coin offering, the actual offering might be a securities offering. But the orange grove, the oranges are not securities. The whiskey barrels at the center of a whiskey investment scheme, the whiskey is not a security. You can drink the whiskey. That's not a security, even if you build an investment scheme around it. And the entire Howey test is designed to evaluate a transaction or a scheme, not an actual object or instrument. And the SEC wants to say that it's not just the offering of these tokens that is a securities offering. They want to say that the token itself is a security. But they're using a test that is designed to evaluate a transaction or scheme built around something that's not a security. And that leads to a fundamental tension in how they're doing this. So they've come up with concepts that maybe the token represents the offering, but then it could morph to not be a security at some later time if it no longer represents the offering. And they're sort of turning themselves in circles to try to square this problem of you using a test designed for a transaction to actually say the instrument itself is a security. And part of the reason they're doing that is they want to regulate this whole industry. If the token isn't a security, then, or let me start the other way. If a token is a security, then the exchanges where you can buy and sell them, The trading platforms are essentially securities exchanges because they're giving you somewhere to buy and sell securities. Then all of those come within the SEC regulatory scheme as well. If the offering of the token initially was a securities offering, but the token itself isn't a security, then it's not clear that the platforms where you can trade the tokens are securities exchanges or trading platforms. So then maybe those don't fall within the SEC's reach. We know the SEC wants all of those trading platforms and exchanges to be considered securities exchanges that have to register. But in order to do that, they sort of have to get to the token itself being a security. And that's what's leading to this tension of how they're applying these tests and whether they're saying it's just the offering that's a security or the token itself and the like.
Right. We definitely could do an entire webinar again on this topic as well. So Kayvon, you seem to be the one that's we're giving you some full webinars that we want you to give us in 30 seconds. So thank you for telling us a little bit more about that. One of the things is we have a few minutes left, and as we have a lot of lawyers and law students on the webinar, we would like to talk a little bit about what do blockchain and cryptocurrency lawyers do? So what's the whole concept? So rather than, I think I'm just going to go around to each one of you, and let's start with just that one question first is, how would you define what a blockchain or cryptocurrency lawyer does? So starting with Robert.
So the way I like to describe my practice is that blockchain is sort of an adjunct legal practice. And what I mean by that is that no legal issue involves just blockchain. It always involves blockchain plus one or two or even three or four traditional legal practice areas combined with nuances related to this new technology. And so, my work is very much an adjunct practice in that sense, in that I deal with a lot of different traditional practice areas, things like data privacy and security, tax, securities laws, anti-money laundering and Bank Secrecy Act compliance, asset tracing and recovery, even tech transactions. We're seeing it come up more and more, patents, patent prosecution. And so I'm always working with experts in some of these traditional fields. And my role is to educate those experts in the technology and sort of legal environment around the technology as they help with and bring kind of their deep expertise to the table to solve a specific client issue. And then another thing that I do a lot of is sort of coordinating amongst different experts to come up with solutions that involve more than one legal practice area. And most of the time, clients in this space have needs that involve 2, 3, 4 different sort of traditional practice areas combined.
Thank you, Robert. Pratt, how about you? How would you talk about what a blockchain or cryptocurrency does?
Yeah, that's a great question, Debbie. One of my favorites. One of the reasons I like that question is because my answer probably changes every 6 months as the industry also evolves. I think one of the comments we made before is that there is yet to exist a comprehensive, sweeping sort of federal landscape for cryptocurrencies. And so really, as Robert was mentioning, the use cases will drive what area of law is relevant. And so if a founder, let's say, wants to apply cryptocurrencies to a custodial and payments type of application, then traditional laws around custody and payments become relevant. And it, of course, requires knowledge in that area versus if one wants to use tokens in a capital raising type of context, they might fall within the securities realms, et cetera. That has for a long, long time been true. However, that is no longer completely true as regimes have emerged. New York State is a really good example of a jurisdiction which has created a native cryptocurrency law, the so-called Bitcoin law. And one could have a specialty focusing on just that law. And increasingly, various states, I think we mentioned, have created legal personhood around native blockchain concepts, and aspects of other laws like the UCC, payments, banking, et cetera, increasingly are creating interpretations and guidance letters that are inherently natively blockchain. And so they're all growing out of these other core competency areas, whether they're securities or banking or payments or derivatives or commodities. But at the end of the day, I would encourage folks to focus on developing core legal skills, drafting, negotiating, litigating, whatever you do, and let your clients take you sort of into the industry that you want to get into, whether that's blockchain or anything else. Because at the end of the day, you will be hired for core legal skills first and sort of industry knowledge second, as opposed to sort of leading with industry knowledge without having those core underlying legal skills.
Very good point. Absolutely. So, Yev, how about you? What can you add to what a blockchain or cryptocurrency lawyer does?
Yeah, I mean, I think Robert and Pratt did a really good job in their descriptions, and I couldn't agree more. I guess I would just add that I really like to kind of roll up my sleeves and get into the technology aspects of what I practice. So, joining a DAO, purchasing crypto, whether on a centralized or a decentralized exchange, and seeing really how the kind of the mechanics of all of this work as I'm speaking to clients. Something that we are doing with my firm that's pretty kind of pioneering the corporate formation space is that we are trying to find the appropriate kind of legal wrappers for DAOs. So we are pioneering DAO cooperatives and aligning those principles and housing them in co-ops, which is pretty new and attracting a lot of attention. So it's all of what Pratt and Robert said, and it's also a lot of kind of ingenuity and being kind of open to not understanding anything your clients are saying, because it changes a mile, like a second or a block, or however you want to term it. But yeah, I guess.
So Kayvon, kind of building upon that, of course, you can add to anything that we may have missed, but can you tell us about your career path in becoming an expert in this field, in the blockchain and crypto field as a lawyer?
Sure, and I think it echoes what everybody else has said, which is you have to be a lawyer to become a blockchain lawyer, and so you have to develop a core competency first, and then you can apply it to this industry or to other industries. I think that's really the best way to work it. So I've been doing litigation and investigations for close to 15 years, largely in the securities financial markets area, before I got into blockchain. I got into blockchain late 2016, and that's when I sort of went down the rabbit hole, so to speak, really getting involved in this technology. And as people in the industry started really focusing on what the SEC was doing in 2017, I was sort of in a natural place to help advise people because there weren't regulations. And I think that's the other thing about what it means to be a blockchain lawyer. You have to be comfortable with a degree of uncertainty because there aren't clear rules of the road. It's evolving very quickly. And so it's hard to give guidance with the clarity that as lawyers, we're used to having around more established areas. But in that space, people were starting to look at the SEC. SEC was regulating by enforcement. They were announcing what they thought by putting out enforcement actions, and everybody was supposed to read them and understand what that meant for other projects. And those of us who'd been dealing with SEC enforcement for, a decade or more had a better read on what the enforcement actions meant and what to take from them than people who hadn't. So that's sort of how I got into the space. I had a programming background before I was a lawyer, so that helped. I wasn't scared to actually read the code. And I agree, you've sort of got to get your hands in, understand what's happening. And there are various levels of doing that. But I think that helps a lot. And then, I think as you progress in the space, it becomes an area of focus just because it's evolving so fast. And it really becomes a full-time job just to keep pace with what's happening in the space so that you know what developments are relevant to different people, and you can sort of talk the talk and understand what's happening in the industry. Because I think in 2017 clients were willing to pay lawyers who they knew were smart subject matter experts to learn what blockchain was so they could get advice. I think more and more now clients expect that they can find a lawyer who already understands blockchain, and they shouldn't be paying for that 101 the same way. And so you sort of need a combination of the expertise plus already understanding the industry.
So thank you all for participating today. I think we covered a lot of different material in a short period of time. Hopefully we gave you some things to think about when it comes to blockchain, cryptocurrency, and law, and some of the hot topics of today. So I'm going to hand it back to Tom to close our program. And again, thank you to our panelists.
Thank you so much, Debbie, and everybody. Before we do have just a couple more minutes, so I wanted to recognize Barbara's post in the chat if folks want to call out resources. She says resource documents for us to review to assess compliance risks for blockchain, but what websites or organizations might you point people to?
I can jump in. When it comes to the SEC has put up a website that tracks all of their enforcement actions in this space, so you can really see how that has evolved and sort of look back at all of them, and that's a helpful resource, I think, from that point. Each of the agencies has their guidance posted pretty prominently, as far as that sort of direct resource. And then there are a number of the sort of publications in the space that have created pretty good resources just to understand the technology and some of the other issues around it. Coin Center comes to mind, but there are plenty of them that have created those sort of resources.
And Tom, I'll add that I put in the chat the link to the weekly blog that I curate and edit for my law firm. It's called the Blockchain Monitor. And what I do with that blog is I have my own methods that I've been using to track this industry for almost a decade now. And I have a blog that we post every Friday where I take, what I believe are kind of the most relevant developments. And I have a whole team of folks at the firm that I work with to package those up in concise blogs, and we provide links to the source documents. You can sign up and you'll get it in your email inbox every Saturday morning, or you can just go to the website that I put in the chat to find the most recent blogs. So that's sort of a free resource that me and my firm offer to the industry.
Wonderful, and I see Yev has added a couple there too. So thank you very much for that. Any other, Pratt, anything? Yeah.
No quick, easy resources, but maybe I should give a shout out to Debbie's class herself. I'm sure that's great, and I'm sure if people want a more in-depth, structured approach to blockchain, maybe that's a good place to look.
That's exactly right. And I was going to say, in addition to thanking you all for your brilliance in this space and for sharing this, I guess I would say point in time update on where things stand. We know that it's rapidly changing. We welcome you. Albany Law School welcomes any of you back at any time to do updates. And Debbie Hoffman herself, Professor Hoffman, will be re-teaching her course, which of course she will need to revise every year she teaches it, I'm sure. And if we don't see you on other webinars, panelists, we will see you, as some of you, as guest speakers in her course, because I happen to know that you appear there too. So if anyone in the crowd has any interest in learning more about the programming at Albany Law School, please do reach out to us. And thank you again for Professor Hoffman and her colleagues, today's amazing panel. And we will all see you soon. For now, this concludes today's event. Thanks, everybody.
Thank you.